Hey, this is Neil's Han Dynasty. Please like, share, and subscribe. Buy some silver, some platinum, and some crystallized osmium. If you want a kitty, ask. I've got several. I'll let you have some. That's Beth. She just broke out of her shell. Anyhow, like, share, and subscribe. Be kind, helpful, and grateful. Buy some silver, some platinum, and some crystallized osmium. And check this out. Not him. He's being a crazy kitty. He's not who you want to check out. This is what you want to check out. This is going to change the world. This right here. Trump DOJ sues entire court of corrupt judges. I'm going to turn this up a little bit.
Automatically, just email autoresponder goes out. Actually, you're injuncted. What? They say you can't do that. You're the judge. Trump administration didn't get any due process. The American people who elected Trump and this administration to effectuate these removals, we don't get any due process. And the court, when they're issuing their orders, don't even provide due process according to their own rules.
We're going to concentrate on national security threats and public safety threats, and that's what we're doing. After the Iran issue this weekend, we just stepped on the gas, adding a lot more resources to it and really hammering it. So
Hey, guys.
We're on it. We're going to do the best we can as fast as we can.
Trump strikes back, files a lawsuit against the entire district court. That includes a bunch of other judges, not just one judge, but this is unusual. We don't see a lot of this here on this channel or in this country, really. We have this happening where the United States of America, Homeland Security are coming in as plaintiffs, and they're suing all the judges. The chief judge, George Russell, Abelson, Bennett, Lake, Boardman, Breder, Chesanow, Theodore Chuang, and we've covered cases from him that have been adverse to Trump. Gallagher, Grigsby, Hollander, Herson, Maddox, Rubin, Zenas, who is handling the Kilmar civil case, not the criminal case, all being sued, including the clerk of the court and the United States District Court for the District of Maryland. Dang, son, all getting sued. So we'll see what happens here and what the judges do, because they're now defendants in this case. And something else that's interesting here, just procedurally and tactically, is now that they're sued, Trump also submitted this. Guess what? You're defendants in a lawsuit. So since we're suing you, you can't judge our cases anymore. So you must recuse yourself under the rules. All of you, get off our cases right now. Saying here also, so we'll come back to the original filing, but this is the motion for recusal. They say, since we're suing all of you, now get off the case and send these to another district. Plaintiffs, the United States of America and Homeland, now respectfully request that each judge of this court recuse himself or herself from this matter. And Zenas might be a themselves. I don't know. Plaintiff also requests that this matter be referred to the Fourth Circuit's clerk office for reassignment of a randomly selected district judge from another district or transfer all the cases to another district. So get off since we're here. Now first, because this court and judges are now named defendants because we're suing you, each judge in Maryland is required to recuse themselves from the matter. A judge shall, under the rules, disqualify himself from a case in which he is a party to the proceeding. You're citing the guide to the judiciary policy. It's your own policy. Even we are not above the policy, judge. Pack your bags. Policy says, when all sitting judges of a court are named as defendants in a civil action, each defendant judge is ordinarily required to recuse from hearing the case under the canons of judicial conduct. Judges have accordingly recused in similar cases, and so you need to do that now. Saying recusal is also warranted under the more general standard under a different provision of the law, which says, actually, you should recuse yourself of any proceeding in which your impartiality might reasonably be questioned, including like when your wife and daughter are Democrat affiliated and adjacent entities. Saying, here's an objective inquiry would lead a reasonable observer to say these judges are biased and should recuse, since they're now being sued. And second, our request that the clerk contact another court is to facilitate a judge who actually can hear this case. Specifically in these circumstances, the Fourth Circuit explains how we do this. We just follow this rule in different district courts. They then contact randomly selected judges and they serve recuse. Oh, it's pretty common. Once such a judge has agreed to preside, then the JSO nominates the chair, and then they transfer certain civil cases transferred out of there, and there was a conflict with the current judges, so they just moved it. And so accordingly, we, Trump, respectfully request that all judges in Maryland recuse themselves. Get off the case. Plaintiffs also request that the matter be referred to the Fourth Circuit's clerk office for assignment and transfer to a better judge duly selected in a different district. And so get your cardboard boxes, judges, and take those cases off your desks. So what you can see is that's just part one. Now, they also submitted this in a much broader filing. They say, we are suing you, and this is what we want. So while this is pending, you guys got to recuse yourself from our cases and this case. And now we are asking for more. Writing, plaintiffs, the United States and Homeland Security and America through Trump bring this action for a declaration and injunction. We want the court to force them to do or not do something. They write, all right, Judge, in the District of Maryland, but these judges cannot hear it, right? So this case should be heard by some other judges because they're defendants. And so we're sending it to Maryland, but the judge should contact another judge and have them hear this case and reassign it. It's all by operation of law. Then I think you might argue that in the other cases, right, just to be clear on this, if the Kilmar cases and like the cases that Judge Zenas is on, you filed, which we might expect to see, a motion to recuse from that case. So we haven't seen that yet, but I would expect to see, Judge, we're suing you. You're sued, get off the case. See the same thing happening probably in Chung's case. Get off the case. They're suing, you're presiding over this case, but since you're a defendant now and we're suing you, you gotta go. So here's what they write. All right, several hundred years of history, court, new judge, they teach that injunctive relief is an extraordinary equitable remedy that is never awarded as of right. Okay? If you're going to force somebody to do something, issue an injunction, you have to do this, or you can't do this, right? That's like a mandate to a person's personal activity. That's a big deal. You can't just do it willy-nilly. It's an extraordinary equitable remedy whereby you're trying to balance the scales of things, and it's never awarded as a matter of right. You don't just come in here and just say, I look at injunction. Oh, sure, here you go. Even where a plaintiff claims that there is going to be irreparable harm. Okay? It's a high standard, in other words. And injunctions against the executive branch are particularly extraordinary, extra high, because they interfere with that democratically accountable branch of their constitutional powers. Okay, if you're going to stop the president from doing something, there are mechanisms built into the Constitution and into our society to do that already. You can impeach the president. If there's a popular uprising, people are mad that Trump's deporting all these illegal invaders from our country, well, they can just complain to their representatives, the ones who aren't representing illegal aliens. And then they can join the ones who are representing illegal aliens, and they can have a majority and impeach and remove the president if it's so egregious. But it's not. And so what they have to do is take a different avenue and use injunctions to exercise powers that they do not have. It is a usurpation of our power, our right, and our structure of governance. Saying here, the core Article 2 powers to enforce the nation's immigration laws and shape and manage its relationships are all being usurped. Despite these elementary principles, what these judges in Maryland can't figure out, in recent months and years, district courts, especially Zenas, have used and abused their equitable powers to interfere with the executive branch to an unprecedented degree. In the first 100 days of President Trump's current term, district courts have entered more nationwide injunctions than in the 100 years from 1900 to 2000, requiring the Supreme Court to intervene again and again in recent weeks, and they're getting scolded for being so pathetic and hands-off on this, to pause the unlawful restraint of our Article 2 powers. Now, this lawsuit against these judges involves yet another regrettable example of the unlawful use of equitable powers, which are these injunctive powers, to restrain the executive. Specifically, injunctions are a remedy in equity. So when they say equitable powers, they're talking about the court being able to force or prevent somebody from doing something. Specifically, defendants, the judges, have instituted an avowedly automatic injunction against the federal government for basically anything, issued outside the context of any particular case or controversy. And they did so by promulgating a standing order. We covered this some time ago. And an amended standing order that require the clerk to automatically enter an injunction against removing, changing the legal status of any alien detained in Maryland who files a habeas petition, right? So the judge basically set in a new policy, like an email autoresponder, essentially. So someone files a lawsuit and the illegal alien gets rounded up by Tom Homan. He's like, you're going home. No more papooses here. So they put him on an airplane, or about to. They file a motion for a habeas petition. Illegal alien says, no, don't take me out. ACLU gangbanglers come crashing their clown cars right into their front door and then represent them. And once that habeas is filed, then the judge has said, you know what, I'm not even going to look at it. As soon as it comes in, like you file it with the court, the paperwork goes out electronically, that gets submitted. Then what you'll see is the judge sets up like an AI chat GPT or whatever. It just automatically says, oh, that's a great petition. We love illegals here. You're an illegal? Habeas? Granted. Issues an injunction, right? So automatically it just comes right back. The clerk is directed without reviewing the case. The clerk's not a judge. The clerk doesn't get to say whether it's a valid petition or not, or whether there's good cause to issue an injunction. It's not automatic. Trump has the presumption of fair operation and good dealing to deport these people, as has been the tradition since forever until Trump came into power. So automatically, just email autoresponder goes out. Actually, you're injuncted. What? They say you can't do that. You're the judge. Now, the challenged orders here do precisely what the Supreme Court has forbidden. You can't do this. They are making equitable relief, an injunction, a matter of right. As soon as an illegal files it, boom, injunction granted. Free injunctions for illegals. You would never get an injunction if you say, the governor is shutting my business down for COVID, and they say that I have no right to my own private physical property. I can't open my doors and enter private contracts with other people who want to come in and get their haircuts. And you have to be locked down for that. You go to a judge and say, Judge, I'm a citizen. I've got rights in this country. They say, get out of my courtroom. They're going to kill everyone in here and throw you out. But if you're an illegal and you're being processed by the federal government and you're following orders of the executive branch, which were these governor executive orders, then you're free not to go. They're going to keep you right here in this country where you shouldn't be. So defendants' automatic injunction from these lunatic judges issues whether or not the alien needs or even seeks emergency relief, whether or not the court even has jurisdiction over the alien's claims. Like, didn't even look at it. They file it right. No matter how frivolous their claims may be, it's automatic. And it does so in the immigration context, and thus it is intruding on core Article 2 powers under the law. The automatic injunction is motivated by the judge's, quote, frustration, their word, in quotes, not ours, with hearings related to the immigration enforcement actions and a desire to avoid handling cases outside the regular business hours. He's like, these illegals keep filing, like at 2 in the morning. Trump puts them on an airplane at 2 in the morning. Their gangbang lawyers file a bunch of documents, 2:15. Judges go, plane's taking off at 2:30. They got to issue an injunction, get out of bed, and do their job. And they don't want to do that anymore. So they just set up an autoresponder, and they say, that's too bad. But a sense of frustration and a desire to greater convenience does not give them license to flout the law, judges, nor does their status within the judicial branch. Just because they're little dictators up there doesn't mean we got to deal with it the rest of the country or accept it as the DOJ. And so the judges' standing orders defy the requirements for issuing an injunction. There are rules that you have to go through before you grant an injunction. You can't just automatically do it. They violate congressional limits on the district court's jurisdiction over immigration. You can't even hear these cases. You're an Article 3 court. Immigration courts are Article 2. Always been that way, since modern era. And they disregard the procedural and substantive requirements for issuing what amounts to a local rule. They are also fundamentally inconsistent with the judicial role only to accept cases and controversies, and they're predetermining a case without even looking at the documents. They're essentially presumed valid when that is not the law. Now, in particular, the district courts lack jurisdiction to hear challenges arising from removal proceedings or even issuing orders to enjoin or restrain the execution of those removals. Congress has expressly and intentionally channeled challenges to removal proceedings to specific court process in the Court of Appeals and imposed various other bars on judicial review. So these judges are meddling in cases they have no power to meddle in. Their automatic injunction extends relief as of right that district courts lack jurisdiction to issue. Okay, they're seizing power, granting benefits to illegal alien invaders. Now they're getting sued. Every unlawful order entered by the district court robs the executive branch of its most scarce resource, time to put policies into effect. They're stealing our term. In the process, such orders diminish the votes of the citizens who elected the head of the executive branch. Oh, that's us. Yeah, the citizens of the country. Defendants, the judges, lawless standing orders are nothing more than a particularly egregious example of judicial overreach, interfering with the executive branch and undermining the democratic process. They're not elected judges. They're not accountable to the people in any way. You could say, okay, maybe through impeachment proceedings, and I would agree with you, and we should have Congress start opening these impeachment proceedings. We've been advocating that for a long time. Start throwing that power around. Where has that been? Why are they tolerating this? Why don't they get rid of these circuits if they want to? Plaintiffs are entitled to prompt relief from defendants' unlawful and anti-democratic orders. And so we're suing all these judges, Russell and Abelson, and you know the rest of them, saying they're a judge of Maryland. They're all there. Same thing for all the judges, all getting sued. Here's what happened. Now, on May 21st, not long ago, the judges, they came out with this new standing order. They said illegal aliens are better than everybody, and so we're going to give them special privileges. Not only due process, but due process plus, due process premium version of America, because they're better than you. The standing order applied to all cases filed on or after 5 p.m. It purported to invoke the All Writs Act and a limited judicial power to preserve our jurisdiction and maintain the status quo. This is why we can do it, because we want to. The standing order also provided that as soon as they file a writ, they are enjoined and restrained from doing anything. You cannot alter their their status. As soon as they file it, right, it's granted. What? The standing order provided that an order to this effect shall be entered in every case upon its filing. As soon as the doc hits, email autoresponder goes out. The standing order provided that its term shall remain in effect until 4 p.m. and there's like an end cap on this so that we can actually get the case and then review it and those things. The standing order directed the clerk to docket the standing order in each relevant case. Okay, so in other words, the clerk gets to decide, oh, a petition came in, it's valid, injunction granted automatically, at least a small injunction.
This is wild. Whoa, sorry about that, guys.